It's a great pleasure to call this meeting of the Standing Committee on Justice and Human Rights to order. As this committee proceeds to its study of Bill C-16, an act to amend the Canada Human Rights Act and the Criminal Code, it's a pleasure to welcome Mr. Gerritsen to replace Mr. Rankin at today's meeting. Welcome, Mr. Gerritsen.
Thank you.
It's a pleasure to welcome Mr. Nader to replace Mr. Nicholson at today's meeting. Welcome, Mr. Nader.
Thank you. Good to be here.
And it is also an enormous pleasure to welcome Minister of Justice and Attorney General of Canada, Jody Wilson-Raybould, for her second appearance before this committee in 1 week, which I think may be a record.
Yeah,
Welcome, Minister.
Thank you.
And I'm also pleased to recognize that Bill Pentney, the Deputy Minister of Justice and Deputy Attorney General of Canada, is also here. Welcome, Mr. Pentney.
Thank you.
And so, Minister Wilson-Raybould, we turn the floor over to you.
Perfect. Well, thank you, and I'm certainly pleased to be here with my Deputy Minister, and pleased for the opportunity to be able to present on Bill C-16 today, and look forward to answering any questions. So in my remarks today, I'll outline the broad objectives of the bill, take you through some specific amendments, and then respond to 3 points that were raised during second reading debate. Bill C-16, an act to amend the Canadian Human Rights Act and the Criminal Code, is an important step forward in protecting equality, dignity, security, and the freedom of transgender and gender-diverse Canadians. Trans Canadians, like all Canadians, should have an equal opportunity to make for themselves the lives that they are able and wish to have. Indeed, all Canadians should be free to be themselves without fear of discrimination, hate propaganda, and hate crime. Sadly, this is not yet the experience of many trans people. As you are aware, trans and gender-diverse people face an elevated risk of violence, including physical and sexual assault, and verbal, physical, and sexual harassment. They also face significant obstacles in obtaining and advancing in employment, and not because of their lack of qualifications, but because of discrimination. Yet our human rights protections and criminal law do not explicitly protect this vulnerable group. With Bill C-16, Parliament has the opportunity to affirm in clear language that trans and gender-diverse people are entitled to equal protection from discrimination, hate propaganda, and hate crime. Canada is strengthened by its diversity, and diversity flourishes when our laws and institutions promote social inclusion and participation for all, which is fundamentally what this bill seeks to do. To this end, Bill C-16 proposes to make 3 amendments. It would amend the Canadian Human Rights Act to add 2 prohibited grounds of discrimination: gender identity and gender expression. As a result of this amendment, it would be a discriminatory practice in matters of employment and the provision of goods, services, facilities, and accommodation in the federal jurisdiction to disadvantaged people because of their gender identity, gender expression. This bill also proposes to amend the Criminal Code. It would expand the list of identifiable groups that are protected from hate propaganda by adding gender identity or expression to the list. Finally, it would make it clear that hatred on the basis of gender identity or expression should be considered an aggravating factor in sentencing for criminal offences. It is not the first time that parliamentarians are studying this issue. Indeed, this House has already passed substantially the same bill twice before. Moreover, most provinces have already made similar amendments. I believe these amendments are overdue. Nevertheless, it is evident from the debate in the House that there are questions about why we need to enact these amendments and what they will do. I listened carefully to the debate and acknowledge the perspectives from my fellow parliamentarians, and I would like to address some of the questions today. Some wondered whether the amendments are necessary. It was pointed out that trans people may already complain of discrimination on the ground of sex under the Canadian Human Rights Act, and that the hate crime sentencing provision is open-ended and would therefore already include gender identity and expression. Allow me to offer 3 responses. First, Canadians should be able to turn to our fundamental laws like the Canadian Human Rights Act and the Criminal Code and see their rights and obligations spelled out clearly. Promoting access to justice means working on an ongoing basis to make our laws as clear and easy as possible for everyone to understand. Trans people who feel that they have been discriminated against should not have to become experts in legal interpretation to advocate for their basic rights. Employers and service providers should know explicitly what legal duties they have towards their employees and customers. Adding these grounds to the Canadian Human Rights Act, as well as the Criminal Code, will ensure they are clear for all to see. Second, Canadians expect parliamentarians to speak on their behalf to the social issues of the day and to affirm their fundamental rights. With this bill, Parliament has the opportunity to affirm that all Canadians should be free and feel safe to be themselves. This House can stand with trans and gender diverse people to affirm their equal rights. It is more than a symbolic gesture. This is about embedding new language of respect and inclusion in two important laws that set basic norms about how we conduct ourselves on a daily basis. This is about the Government of Canada sending a clear message to all Canadians and that all Canadians are protected by and have the benefit of the law. The third reason will be of special interest to this committee in its role of studying and recommending improvements to Canada's justice system. This legislation will fill an important gap in the criminal law. The Criminal Code's hate propaganda offences currently extend to the ground of sex, but there is no mention of gender identity or expression. As you know, gender identity is not the same characteristic as sex. Because criminal prohibitions are interpreted narrowly, in order to ensure that the offence protects against hate propaganda which targets trans and gender diverse individuals because of their gender identity and expression, it is important for Parliament to legislate explicitly on this point. We also heard questions about why gender identity and expression are not defined and whether their meaning is too subjective. Again, let me offer some comments. Gender identity and expression are now found in most provincial human rights codes. Commissions, tribunals, and courts are expected to elaborate the meaning of such grounds in a reasonable way with reference to the purpose of the law. They clarify these grounds, and indeed all grounds, through application of real-life examples, allowing the law to respond to individual situations in line with its purpose. This does not mean that grounds are completely open-ended or that people can claim protection on a whim. There are real limits to what any ground can mean. The Federal Court of Appeal has insisted that the grounds of discrimination in the Canadian Human Rights Act must be interpreted in ways that do not trivialize the Canadian Human Rights Act's important role in the legal system. By way of comparison, the ground of religion is also undefined in the Act. Yet one's religious beliefs are subjectively determined. As the Supreme Court of Canada has stated, legal protection depends on the religious beliefs being sincere, a requirement that tribunals and courts are used to assessing on an individual basis. Finally, we've heard that there are diverse understandings of sex and gender in Canada. Some may ask whether these amendments would lead to criminal prosecution of people who express disapproval of diverse gender identities or expressions. The answer is no. As explained in the statement of potential charter impacts that I tabled at second reading, the amendments to the hate propaganda provisions respect freedom of thought, belief, opinion, and expressions in a free and democratic society. The criminal prohibitions on hate propaganda impose a narrow limit on expression. This limit is demonstrably justified in a free and democratic society given the important objective being pursued, namely to target extreme and dangerous speech that 1. Advocates genocide, 2. Willfully promotes hatred, or 3, incites hatred in a public place likely to cause a breach of the peace against vulnerable groups. The target is speech that promotes unusually strong and deeply felt emotions of detestation or vilification, which is far from the expression of religious faith, dissenting views, or even opinion that some may find offensive. The Canadian Human Rights Act is concerned with protecting, for all persons, equal access to goods, services, and employment in the federally regulated sector. It is not concerned with regulating the expression of one's beliefs. Rather, the Act prohibits discriminatory practices, including harassment, when harassment is inflicted in the employment context or in the provision of goods, services, facilities, or accommodation available to the general public, commercial premises, or residential accommodation. As interpreted by the courts and tribunals, harassment involves serious incidents of persistent treatment that accumulates to create a hostile environment in these contexts. In other topics that have been raised in the debate, or many other topics have been raised in debate in the House. However, several of them concerned matters of provincial jurisdiction, and others referred to situations that are outside the scope of the bill, keeping in mind that the Canadian Human Rights Act applies only in the federal sector. This means that it applies to the federal government in its role as employer and service provider, and to federally regulated private sector, including Crown corporations, interprovincial and international transportation companies, telecommunications, the Postal Service, and chartered banks. To conclude, I encourage this committee to focus on the real subject matter of this bill. It is about equal opportunity for trans and gender diverse persons in employment and access to goods and services. It is about increasing their sense of security and freedom from the most extreme forms of hate speech, including calls for genocide and its promotion. It is about denouncing what we know are still all too frequent acts of violence and other crimes when they target persons out of bias, prejudice, or hatred based on the individual's gender identity or expression. Surely we can all agree that these objectives are pressing and in urgent need of being addressed. Bill C-16 would make the amendments needed to pursue these crucial objectives. Thank you for the opportunity. I look forward to questions.
Thank you very much, Minister, for your opening remarks, and we will turn to questions. So first up is Mr. Falk.
Thank you, Mr. Chairman, and thank you, Minister, for coming to committee twice in 1 week. And also to Mr. Pentney, thank you for coming as well and for the good work you do on our behalf. Mr. Pentney, I'd like to start with you. In a Department of Justice backgrounder issued on May 17, 2016, the department, which I assume you're responsible for, stated that the criminal code also provides that a judge, when sentencing someone for having committed an offense, must consider any relevant aggravating circumstances, including if the offense was motivated by bias, prejudice, or hate based on race, national or ethnic origin, language, color, religion, sex, age, mental or physical disability, sexual orientation, or any other similar factor. It goes on to say this phrase is broad enough to include gender, identity, or expression. That's a backgrounder from your department, sir. So I'm wondering, changing the criminal code, as this bill is suggesting to do, how would that impact criminal proceedings? What are really the palpable differences? And are there things in Bill C-16 that are covered that presently don't exist in either the Canadian Human Rights Act or the Criminal Code?
Well, thank you for the question, and I would invite my deputy to respond if he wants to add.
Thank you, Mr. Pentney.
But in terms of Bill C-16, we are providing clarity with respect to the Canadian Human Rights Act and clarity with respect to the Criminal Code, as well as adding it as an aggravating factor in sentencing to make the law clear, to ensure that we provide for the protection against discrimination for individuals based on their gender identity and gender expression. This provides the necessary clarity and the ability for individuals to feel safe to be themselves.
And I would add that there is a clear gap in terms of some provisions, certainly in the Criminal Code, in the sense that, as the Minister has stated, the code will be interpreted narrowly. And so in order to determine whether or not that other similar factors would include gender identity, gender expression, there would be an argument that would be required that would not be required if the words were plainly stated in the provision. Second, that in terms of the promotion of genocide, there is a clear gap there. There would be no reasonable way for a court, we think, applying the doctrine that applies in terms of how to interpret the criminal law narrowly so as to protect to the maximum extent possible the liberties of the individual, to apply the kind of interpretive approach which has been applied historically and previously by human rights commissions, a broad and liberal interpretation. So in terms of the sentencing provision, there would be an extra argument that would be required that would be eliminated by the clarification that the bill proposes. In respect to the promotion of genocide, we believe that there is a clear gap that would be filled by adding the expression. And in respect of the Human Rights Act, as the Minister has said, the Human Rights Act is recognized as quasi-constitutional. Short of the Charter, it stands above other laws, with some other fundamental laws that the Supreme Court has also recognized as quasi-constitutional. And the purpose of the bill is to make clear to all Canadians what Parliament in Canada stand for in respect of standing against discrimination.
Well, I don't argue with what you're saying, although that's not consistent with what your backgrounder said in May of this year. Your backgrounder suggested there were no gaps, and currently everything would be covered under existing legislation. November the 27th, 2012, at the Standing Committee on Justice and Human Rights, Mr. Ian Fine, the Acting Secretary General and Secretary General's Office for the Canadian Human Rights Commission, stated that the Commission, the Tribunal, and the courts view gender identity and gender expression as protected by the Canadian Human Rights Act. Goes on further to say, if someone experiences discrimination based on gender identity or gender expression, they are currently protected under the Canadian Human Rights Act. That was from Mr. Ian Fine. In June the 3rd of 2013, before the Senate Standing Committee on Human Rights, David Langtree, the Acting Chief Commissioner of the Canadian Human Rights Commission, stated the Tribunal and the courts view gender identity and gender expression as protected by the Canadian Human Rights Commission. Also went on to state that someone experiencing discrimination based on gender identity or gender expression, they are protected under the Canadian Human Rights Act. The Commission already accepts complaints that raise transgender issues. Minister, in May of this year, you were participating in CTV's Power Play with Don Martin. And in response to a question regarding legal recourse, you stated, Minister, there is recourse under the Canadian Human Rights Act in terms of sexual orientation. By your own admission, this bill doesn't change anything. Why have you chosen to put forward a bill that really doesn't add a lot of value and the meaningfulness of it is minimal?
Well, I appreciate the question, and I even more appreciate the opportunity to provide an answer. I believe and am confident that Bill C-16 does something substantial in terms of amending the Canadian Human Rights Act to explicitly and in clear language add gender identity and gender expression as a prohibited grounds. I want to acknowledge the decades of advocacy on behalf of the trans and community to ensure that we have been able to get to this place wherein, as a parliament, we have the opportunity to recognize that discrimination against trans individuals, individuals that have a different gender identity or gender expression, are now clearly protected under the Canadian Human Rights Act. And furthermore, to add them as an identifier to the identifiable groups under the criminal code and have gender identity and gender expression added as an aggravating factor in sentencing goes to the intent which I am very proud of in terms of Canadian values and recognizing that as a country we are stronger in terms of our diversity, and we need to ensure that we do as much as possible to eliminate and eradicate discrimination wherever it finds itself in our society.
A very short question because you're out of time.
If I'm out of time, that's okay.
Are you sure?
I'll come back.
Okay. Mr. Biddle.
Thank you so much, Mr. Chair. Minister, I wanted to thank you for appearing here today, but I also wanted to thank Mr. Garrison for his work in previous parliaments in bringing this type of legislation forward. So thank you very much. Minister, over the past 20 to 30 years, there's been significant developments in law and rights for the LGBT community. Hope this is another piece of that puzzle for a more inclusive society. Can you please inform the committee as to why this is one of the first pieces of legislation that you decided to bring forward as Minister of Justice?
Well, as the Minister of Justice and the Attorney General of Canada, specifically as Minister, I feel and take great pride and responsibility to ensure that we live in a legal and political system that will protect us, regardless of our race, regardless of our sexual orientation, regardless of our faith. And for me, in terms of my responsibility and looking at the substantive amount of work that had come before me in terms of presenting bills back to Member of Parliament 6A and Mr. Garrison, as well as Member of Parliament Fry, and the trans population across the country that have elevated this to the point where they have articulated where they felt discrimination, and to do our part as legislatures and my part as minister, this was pretty much a no-brainer and something that I'm very pleased to have been able to follow up from the many who have advocated this in the past and put forward Bill C-16, and I very much hope that this bill goes through our parliamentary process and becomes law, so we can amend those statutes to provide for and eliminate discrimination as much as we can.
Thank you, Minister. Discrimination against trans people in society is significant. You touched on it. Trans people face higher levels of depression, suicide, inability to find work. Can you describe how this legislation will help trans people and punish those who discriminate against them?
Well, I believe that this legislation is a clear statement on behalf of the Government of Canada and further on behalf of parliamentarians that would say that discrimination in any way, shape, or form is unacceptable in 2016, and that we clearly recognize the challenges that individuals in the trans community face, and when they face discrimination, there is recourse through the Canadian Human Rights Act, explicitly stated in terms of being able to hear their cases of discrimination, and when individuals who express their gender identity or their gender expression beyond norms have the ability in terms of criminal proceedings around hate speech or hate propaganda to have avenues for redress in that regard as well.
Thank you. And I'd like to build on something that was commented on by Mr. Falk a few months ago in the Catholic Register, in which he said that this legislation is forcing people to give up grounds in their personal right to share a bathroom with someone who may not identify with their biological sex. Could you please comment on that? I believe it's troubling personally, but I'm wondering if you could comment on those types of views.
In terms of the concerns that some have expressed in terms of accessing bathrooms or going into, well, I find it troubling as well. I think the very fact that questions are raised about concerns in terms of somebody that clearly identifies one way or the other, there's a creation of fear of that person going into one bathroom or the other. The fact that we're having this conversation is the very reason why we need to have Bill 16 in place. I hope as a society we will overcome these negative stereotypes and recognize that individuals should be free to be themselves, and when they are free to be themselves, our society benefits.
Thank you.
Minute and a half if you have another question. Ms. Khalid? Yep.
No, I'm okay, thank you.
Okay, so then Mr. Garrison.
Thank you very much, Mr. Chair, and thank you. I'm very pleased to be able to join the committee for this session, and very pleased to be able to talk to the Minister about this today. I want to recognize the sense of urgency with which you've adopted your approach to this legislation. And Mr. Falk raises questions that are theoretical in the future about what might happen. And to me, what's important about this bill is it addresses what actually happens every day in our society. And Mr. Biddle made reference to high levels of unemployment among the transgender community, despite very high education levels in general, and very severe poverty suffered as a result of those levels of unemployment in the transgender community, plus very elevated levels of violence. So I applaud you for the sense of urgency which you brought the bill forward. This has been before Parliament in one form or another for nearly 12 years and has already passed the House of Commons twice, only to die in the Senate, unelected Senate, I should say, twice. So I really do applaud your sense of urgency, and I hope we can keep this bill moving. Secondly, I think today you're framing this in terms of access to justice is very important, and perhaps something we neglected in the past. And I particularly liked your comment that everyone should not have to be an expert in legal interpretation to discover that this kind of discrimination is prohibited. And I think that's key. If some of the arguments that are made is that this is already covered, everybody already knows this, then I don't think we'd have these levels of discrimination that take place right now. I don't think everyone understands that this is covered by our various forms of legislation. And secondly, there are gaps, as we've acknowledged. And by forcing transgender people to go into the legal system and argue that they're like other people, that their discrimination is like something else, adds an unnecessary complication to their approach to the legal system. So I think that's very important. So I do actually have a question, and I would like us to talk about what the bill will actually do instead of what it doesn't do. This bill doesn't do anything about bathrooms. This is really not about bathrooms. So there are some areas of federal jurisdiction where it will have impact. Discrimination in employment, in things like banking, where I have to say the TD Bank, the Royal Bank, have run well ahead of the government in this, and they have very progressive human relations, employment relations, policies in place. And the unions in federal jurisdiction like Unifor have taken very progressive policies in helping come up with ways to transition in the workplace. So there's one where there may not be as great an impact just because people are already moving and we'll be catching up. But in others, I'd like to talk a little bit about two things. One is corrections and immigration detention, where we have had problems with people being placed in dangerous positions as a result of policies. And second, the question of air travel and the examination of gender at the gate in airports. And so I just wonder if you could comment on either of those and the kind of changes we might see as a result of this legislation.
Sure. Well, first of all, to echo comments from other members around the table, Mr. Garrison, to commend you for your persistent advocacy in this regard, and certainly probably one of the main reasons we're sitting around this table. I share your sense of belief that this is something that needs to be done on an urgent basis, and that's not to say that having Bill C-16 become law means it's the end of the work that we have to do. And so the same sense of urgency I have for the work we need to do after I hope this bill comes into place. And there are discussions that we're going to need to continue to have on that urgent basis around how we are going to deal with individual circumstances, whether that be travel for trans people, how we accommodate the identification on forms, how we accommodate individuals in correctional facilities. These are ongoing discussions that I'm committed to having, ensuring that we engage with the appropriate departmental officials and engage with stakeholders to get feedback on it. But certainly in particular cases, whether that be somebody that is in a correctional facility, it's going to depend on the particular circumstances of the individual case. But we need to have those conversations and find where those accommodations have taken place and how we can successfully do that more broadly. I'm committed to ensuring that I engage with my colleagues in government, as well as looking to what has already started to happen in the area of identification, whether that be in immigration or border crossing or otherwise.
Thanks.
Mr. Garrison.
Sorry?
You have a little bit of time left if you have another question, Mr. Garrison.
I do. One of the gaps, my background is in criminal justice. I taught criminal justice 20 years before I came here. And one of the gaps in regard to transgender people is actually the collection of good statistics about violence. And I wonder if the minister or deputy minister could comment on that gap, that we really don't keep hate crime statistics in any form that's useful on transgender people.
Well, thank you for the question, and I would say that it's a subset of a much bigger, an important subset, but a subset of a much bigger question, which is so much of the criminal justice administration right now, done provincially, done locally, by city police forces, provincial police forces, or the RCMP, is not capturing a lot of data about the way that the system is working. We've seen efforts to address that in terms of racialized policing, certainly, and a variety of efforts to gather better data and try and understand what that data tells us about the lived experience of people. I think this will be another situation where, as it's clarified in law, there's a whole variety of tools and practices that then will have to adapt. The minister mentioned identity documents. There's work federally and work with provinces and territories. The Canadian Human Rights Commission, we're confident, will take efforts to educate, to work through practical examples, to do more in terms of outreach, and then working with our provincial and territorial colleagues around data on hate crime, on sentencing provisions. You mentioned hate crimes, as you know, on sentencing as well. Much of the work of sentencing judges is not captured in any systematic way. That's no criticism, just the way the system has worked. So the minister was just at a meeting with our provincial and territorial colleagues, and one of the elements of consensus, I think I can say, among all ministers is the need to understand more about what happens in a day-to-day way in the system, and we would include this among others. It's a very important element, but it will flow from clarification in the law as well.
Thank you.
Merci beaucoup, Monsieur Garrison. On va passer à Monsieur Fraser.
Merci beaucoup, Monsieur le Président.
Thank you, Mr. Fraser. Merci, thank you, Mr. Chair.
I want to say thank you for bringing this important bill forward and the excellent work on this and doing so in an expeditious manner. Also recognize Mr. Garrison for the good work you've done, and I think this is another step forward in our country's history of doing what we can to make sure that people are not discriminated against. I want to ask a question. I fully support the bill, and there's no doubt about that, but I know that there had been some criticism. Some opposition mentioned that gender identity and gender expression are not commonly understood, and it's not defined. And I'm just wondering if adding these terms, I know some people have suggested in the past that maybe adding these terms would add vagueness to the law. I don't agree with that, but I would like to hear your thoughts on it.
Well, thank you for the question. And in terms of the definitions for gender identity and gender expression, we haven't, as I said, included definitions in terms of the Human Rights Act. Most of the prohibited grounds do not have definitions, save and except disability and I believe around pardons. So there's definition applied around those, but it is to ensure that the protections in terms of discrimination are as inclusive as possible. And as the deputy indicated, the Canadian Human Rights Commission potentially will consider providing, in addition to what they already have, a frame around these terms, gender identity and gender expression, but the reality is that discrimination in these areas could take many different forms, and things change, and individual circumstances are different that need to be taken into account in terms of the discrimination, but some guidance potentially could be provided by the Canadian Human Rights Commission.
Can I add just one?
Yeah.
May I just add one additional element that Canada is blessed to have a quite remarkable legal search tool called CanLII, which gathers cases from all across the country. So this morning I took it upon myself to enter the search term gender identity in CanLII, and what I found was 4,091 hits. Decisions from Ontario, from courts, from workplace compensation tribunals from the Northwest Territories and others. I entered the search terms gender identity and expression this morning and came back with 2,266 hits. There is ample jurisprudence working through specific cases and practical examples from human rights tribunals, from courts, from other related bodies. These aren't academic articles and otherwise that are being cited. These are all decisions of one form or another, labor arbitrators or others. So there is an ample body of jurisprudence around what those terms mean that has been worked out case by case in particular circumstances. That's how human rights law has generally evolved in Canada since 1960, when the first comprehensive law was adopted in Ontario.
Thank you very much for that. I'm very familiar with CanLII, and it's important to get that on the record. But, Minister, with regard to gender identity and the definition of gender identity and gender expression, it's not the same as sexual orientation, and I just want to be clear on that. And I wish you would. I hope you can comment on that difference and the importance of the need of putting it in the list of enumerated factors in the code.
A comment on the definition of gender identity and gender
not
expression
being the same as sexual orientation, why it's important to actually enumerate this and not just leave it to a non-exhaustive list and try to maybe put it somewhere else under sexual orientation, which some people may think is the same thing.
Well, yeah, I mean, they are different, and in terms of definitions, in gender identity, I know individuals who probably define this better than I, but the definition that we have and that we have been speaking to is that gender identity is each person's internal and individual experience with respect to gender, their sense of being, and I'm a woman, a man, both, neither, or somewhere along the gender spectrum. And in terms of gender identity, this is the outward reflection of gender expression, rather, publicly, how an individual publicly presents themselves, whether that be in terms of their hair, their body language, their voice, or their makeup.
Okay. Another minute? Okay. With regard to the search of decisions, I'm wondering if, and perhaps the Deputy Minister may be better placed to answer this, do we know of any cases or what body of case law there might be with taking gender identity or gender expression into account as an aggravating factor on sentencing? Do we know if there have been examples of that?
I'm not aware of any specific examples of that, no. But we can certainly undertake to confirm that. And I would hesitate to say we can be comprehensive because of the way in which these matters unfold, but I'm not aware of any cases.
Right, and I think you're correct, though, in suggesting there has been many cases that have been reported and are on CanLII, but it would be true as well that other decisions that weren't reported, perhaps at lower levels, may also include, determinations based on gender identity or gender expression. But I agree with the point that it's very important to clearly express it so that lower court judges have that word there that they can use as an aggravating factor on sentencing. So thank you very much for your presentation.
Thank you very much. And you reached agreement just at your 6-minute mark. So excellent. So we'll now move to the second round, and we start with Mr. Hussain.
Thank you, Mr. Chair, and I'd like to thank the Minister for coming back to the committee and for Mr. Pentley as well. And I'd also like to recognize once again the good work that Mr. Garrison has done on this matter, and it's important to acknowledge that. Just to start, Minister, I want to thank you for introducing this bill and for working towards fulfilling your mandate on this issue as set out by the Prime Minister in his ministerial mandate letter. My first question has to do with if you can give us a sense of the other issues faced by members of the transgender community and LGBTQ communities in the justice system, and what other measures you would take, you would consider in the future to deal with those issues.
Well, that's a really broad question, but a really important question. And I'm very much looking forward to ensuring that we take a very comprehensive and I take a very broad interpretation of the Prime Minister's mandate to me in terms of looking at and doing an overall review of the criminal justice system, including sentencing reform. And in doing so, recognizing that we need to identify measurables or signals that we are making progress. And one of those signals, and this is further identified in my mandate letter from the Prime Minister, is to look at the overrepresentation of Indigenous persons or other marginalized persons, persons that have been discriminated against for many reasons that deal with higher level or upstream societal realities, whether that be poverty, marginalization, the lack of housing, etc., and look to having a review of the criminal justice system that addresses those social concerns, so we do not have a justice system that is the catch-all for our social ills, so to speak. So in terms of individuals that suffer discrimination based on their gender identity or their gender expression, or individuals that are in the justice system because of the fact that they have a mental illness or addiction, or that they are Indigenous, we need to be very mindful that the criminal justice system disproportionately impacts these individuals, and we have to and are committed to doing better to address these broader societal issues in terms of looking at the criminal justice system broadly and ensuring that when individuals find themselves in the justice system, that we create and provide off-ramps for that, and also have preventative measures. But I guess in terms of discrimination generally and the recognition that we want to continue to live in a fair and a just society, I consider it the most essential part of my mandate as the Minister of Justice, having come from a population that has been discriminated against historically and to a certain degree is still discriminated against. This is the most important thing that I can do in my role as Minister of Justice, is to recognize and acknowledge where discrimination exists and do my part to build consensus among parliamentarians and raise awareness among Canadians that it's not acceptable, and our society will be the better for it when we do as much as we can to eliminate that discrimination wherever it exists.
Thank you, Minister. I was encouraged by something you said earlier. You said part of your motivation is to combat hate and discrimination wherever it finds itself. And specifically now we're talking about transgender people. The old Section 13 of the Canadian Human Rights Act was removed by the last Parliament. This section permitted rights complaints to the Federal Human Rights Commission for the, quote, communication of hate messages by telephone or internet. Canadian Bar Association and other human rights groups have argued that Section 13 was an important tool in helping to combat hate speech. My question has to do with, in your efforts to combat hate and discrimination wherever you find it, including hate and discrimination and hate speech and messages against transgender individuals, would you, in your review, consider looking at Section 13 again? Because it was an important tool to combat this type of messages.
Well, I appreciate the question, and it fits quite nicely into my previous comments in terms of doing everything we can to eliminate discrimination, to eliminate hate speech that is projected upon any individual in the identifiable group. It's part of the review that I'm undertaking, and that review is looking at actions that were taken by previous governments, and certainly that is something that we can consider looking at in terms of Section 13, but how we can make that more broadly applicable across the work that we're seeking to do.
Thank you very much.
If I can just add, if there's time, can I just add one thing, which is that as members would recall, one of the rationales for deleting Section 13 was that the hate provisions in the criminal code were the more appropriate way of dealing with extreme speech, and it underlines the importance of clarifying in the criminal code exactly what is covered, filling the gap in the promotion of genocide, and clarifying the definition of identifiable group in the hate promotion speeches. In this interim period, adding gender identity and gender expression to the list of identifiable grounds in the criminal code would therefore be even more important in this absence, because as it stands now, without Section 13 and without those provisions in the criminal code, hate speech, promotion or advocacy of hatred or violence towards these groups is not in and of itself a criminal offense.
You're saying,
Thank you.
an interim until we. Okay.
I think the minister's indicated a willingness and a commitment to looking at Section 13, but with C-16, Parliament would have an opportunity more immediately to provide at least some protections in the criminal law.
Thank you very much. Mr. Cooper.
Thank you very much, Madam Minister and Mr. Pentney. I want to first of all say that I support the underlying intent of the bill. I stand in opposition to all forms of discrimination against transgendered Canadians, and that's why I voted for this bill at second reading. One of the concerns or issues that I did raise when I spoke on the bill in the House of Commons was the need for the bill, and I appreciate, Madam Minister, your efforts to address that issue this morning. I noted when I was going through some of the cases that have been decided in terms of interpreting the term sex under the Canadian Human Rights Act, the Kavanaugh and Correctional Services decision, the Montrol and National Bank decision, the Montrol and Canadian Forces decision, the Nixon decision out of the British Columbia Court of Appeal. But in all of those decisions, the courts and the Canadian Human Rights Tribunal did interpret sex to include persons who are transgendered. Are you aware of any cases where the term sex was interpreted narrowly against transgendered persons?
I'm not aware, and I looked over at my deputy, and he confirmed that he's not aware of any either.
Thank you for that. The only other question I have is Bill C-16 is really a successor to Bill C-279, which had been put forward by Mr. Garrison in the last Parliament. And at one point in Bill C-279, expression was removed from the bill, and it was limited to gender identity. Could you maybe explain the rationale for including gender identity and expression in terms of the language in the current bill?
I mean, I can explain why it's included here. I certainly would look to my deputy to explain why it was taken out before. But I very much appreciate the legislation that was put forward in its full package to recognize gender identity, but also gender expression as a grounds of discrimination. Certainly, we heard from many groups in the trans community that we needed to be comprehensive because discrimination does not just befall one's gender identity, but certainly manifests itself in terms of an individual's gender expression. So we wanted to ensure, engaging with very knowledgeable members of Parliament as well as members of the community and stakeholders, that this was something that was deeply felt needed to be included, and it needed to be inclusive to ensure that individuals, whether in terms of their gender identity or how they express their gender, is included both in the Canadian Human Rights Act and in the Criminal Code.
Those are all my questions, but maybe I will, Mr. Falk, if you have, like to use.
There's about 2.5 more minutes, Mr. Falk, in this round, if you would like to use them.
You stated that part of your rationale for presenting this bill at this time was because of the advocacy that that had been present over the many years, and also to the current government. Advocacy is one thing, but and another rationale that you indicated was because you wanted to make it explicit in law. But you don't disagree that it is covered in existing legislation.
Well, I mean, the Canadian Human Rights Act has covered this in terms of sex, but what we wanted to do is make it very clear and explicit so individuals will know how the law and what the law is, do not have to advocate or become legally enabled to determine or find themselves within another definition, but that it is clear. And in terms of the criminal code provisions that are essentially interpreted quite narrowly, we wanted to make it clear that gender identity and gender expression are specifically included.
You know, and I want to state that I'm against discrimination as well. But there's many minority groups with a much larger representation than the trans group people that don't have that explicitity in legislation today. And why would you offer one group explicitity like you're offering people on the basis of sexual orientation and expression when there's many other minority groups which maybe perhaps also could benefit? I think the reason that previous governments haven't done it is because the broadness in the existing law is of benefit to all groups, including all minorities. But you've obviously consulted studies or you've examined data that would lead you to the conclusion that you have, and I'd like you to cite some of that, please.
Well, first of all, I feel I'm compelled to respond to some of the comments that you made, and if there is another group that isn't recognized in the prohibited grounds or an identifiable group, I would very much like to know what those groups are. I would further say that the reason why there are protections in the Canadian Human Rights Act, it isn't dependent upon, in my view, the number of individuals that experience discrimination, whether that be large or whether that be lower. Human rights are human rights, and we need to ensure, whether it's a small group of people or a large group of people, that we provide the necessary protection for those individuals. That's why we've introduced Bill C-16. That's why years of advocacy in this regard have brought us to this place. The prohibited grounds of discrimination in the Canadian Human Rights Act are quite broad and are clearly articulated so as not to exclude anybody that is finding discrimination. I would put the question back to you. You say that there are many others that aren't included explicitly. I would very much like to know, and perhaps we can have a conversation about that offline, but would be interested in your thoughts in that regard.
Thank you very much. I also just want to make one clarification that sexual orientation is already covered under the Human Rights Act and the Criminal Code. It's gender identity and gender expression that we're now trying to cover. So let's, just so that everybody has the lexicon correct, we now move to Mr. McKinnon.
Thank you, Chair, and thank you, Minister, for appearing before us once again this week. And thank you to Mr. Garrison for his many long years of activism on this file and keeping it on the front burner. Most of my questions have been addressed either in your remarks, Minister, or in the very many excellent questions. I just have one quick question, and then I'll share my time with Ms. Khalid. Can you speak about the experiences of jurisdictions that explicitly identify gender identity and/or expression as a prohibited ground of discrimination, either within Canada or abroad, and have they reported a noticeable increase in accessibility for those individuals or a decrease in criminal offenses against them?
Well, that is an excellent question, and in terms of Canada, the vast majority of the provinces and territories have legislated in similar ways. The first territory, our first jurisdiction to legislate was the Northwest Territories in 2002, and across the country in terms of gender identity and expression now explicitly included, we have Alberta, British Columbia, Newfoundland and Labrador, Nova Scotia, Ontario, Prince Edward Island, and Quebec, and gender identity is explicitly included in Manitoba, the Northwest Territories, and Saskatchewan. In terms of the data and the impact of legislating in this regard, I don't have those numbers on the top of my head, but would be very much willing to provide and consult with my colleagues in the provinces and territories to see if they have collected data. in this way, but I don't know if the deputy has any specifics that he could address.
Not specifically. I think one would find that there have been numbers of complaints filed in various human rights commissions, but as with other types of discrimination, sexual harassment, and other things, when they're explicitly listed, they do not magically disappear from the society. Commissions use a combination of education, providing practical guidance to employers and others, vindicating rights through individual cases to try to change the social norm, and over time one hopes you move the yardsticks that way. But I don't believe you'd find jurisdictions that have adopted that, even going back to the Northwest Territories, to say that it has removed the problem. They would all say that they have now a firm legislative tool as a basis for all of those other activities, and a way of, through individual cases, making clear what the state believes, and second, that there is a practical way for individuals experiencing discrimination to vindicate their rights. And that's been the genius of human rights law and human rights commission throughout its life in Canada.
Thank you.
Ms. Khalid?
Thank you, Chair, and thank you, Minister, and Mr. Pentney, for coming in today and speaking about this very important topic. Being from a minority group myself, I really understand the importance of a bill like this to really recognize that we as Canadians, we celebrate each other's differences, and we're strong because of it. I really do support the spirit and the intent of this bill, and I think it's a great step forward for Canadians. My question then is, with the frontliners, the people that are dealing with the hate crimes, they don't always have, and I can see around this table as well, we don't have a clear understanding. I think mainstream Canadians may not have a clear understanding of the difference between gender expression, gender identity, sexual orientation. And when we have the frontline workers that are dealing with these types of hate crimes, is there anything that can be done or that is being proposed to assist with these frontline workers, such as police officers, prosecutors, defenders, judges, to help understand so that victims' rights can be better protected?
I think that's an extremely important question and an extremely important point to raise. And the ongoing discussion over decades around gender identity, gender expression, around discrimination based on other marginalized individuals is something that we need to continue to elevate in the public discourse. The way that societal norms change and evolve is by having discussions and ensuring that we can be provided with and we access information to understand differences. Not that differences are wrong, that's why we're, as you say, such a great country. In terms of looking at the actors in the criminal justice system, all the actors from the RCM police to other police forces to prosecutors, defense counsel, judges, these are individuals that may or may not have been confronted with differences, but we need to ensure that there's training. We need to ensure that we're doing as much as we can to recognize the differences between and among us, not that one is better or worse, but that there may be some implicit bias that exists. We need to have training in terms of diversity, training in terms of explicit bias, and just training on how we are able to most effectively, whatever we are acting or wherever our place is in the criminal justice system, that we're responding based on the recognition that this is an individual coming before us that might be different, but that they're dealt with fairly, consistently, and that we have the tools and do our part to provide the tools for individuals to be able to recognize and do their jobs as best as they can.
Thank you. Thanks. As you said, Minister, this is a bit of a no-brainer, and I can see around the table that there is general consensus for how important this bill is. And if I may, I'd like to share a bit of a story with members of this committee and yourself, Minister. In Toronto, there was a partner of a law firm who had been the partner of this law firm for many, many, many years and had a number of employees under, at that time, him. And one day came into the firm, and he was wanted everybody to refer to him as a female. because she felt that that was her true gender. And the discrimination that she felt within the law firm was tough for her to deal with, and then ultimately had to basically leave the firm at that point. So, it's the point you raised is so important that we must get past what our physical differences are, what our individualities are, and really talk about what our capabilities are, and really work on the merits. So thank you very, very much on bringing this bill forward. I think it's just a fantastic thing that you're doing. Thank you.
Thank you. That was beautiful. Wow, Mr. Falk.
Sure. Minister, I'll come back to my question that I asked you, which I'm not sure you adequately answered. Can you give me or reference any studies or data that you included in your decision to introduce this bill?
Studies or data with respect to discrimination?
Towards transgenders, yes.
Well, I've had the benefit of meeting with a myriad of stakeholders, advocates in terms of the trans population, one-on-one conversations, which I take incredibly serious, and reference the situation that the member speaks about in terms of discrimination of the individual in the law firm. I've heard many stories in that regard. I've heard from and read testimony in the Blues around previous iterations of this piece of legislation and the advocates that presented on behalf of the legislation, whether it be around committee tables like this or in the other house. So there is a substantive body of testimony, of personal reflections and factual circumstances that without equivocation lend itself to ensuring that we pass Bill C-16 as fast as we can.
So in other words, there is no data that you've referenced, there's no studies that have been done on this issue. It's just a matter of people that have been effective in their advocacy.
Well, I think we're going to have to agree to disagree on that one, Mr. Falk.
Well,
there are
just tell me.
amounts of studies. Individual jurisdictions, Canadian Human Rights Commission, commissions in each of the provinces and territories have had great discussions on this and produced different documents to reflect the need and the reality of gender identity and gender expression. And I would be very hard-pressed to say that having personal circumstances and individuals present themselves to me is not direct evidence of the reality and the need to have this. Other jurisdictions, governments, provinces, and territories have conducted studies on transgender. I'm sure that we can provide you with a substantive list of the documentation and the publications out there that can further clarify or further address your question.
Well, my question is, you yourself haven't looked at any studies or examined the data in bringing this legislation forward. Is that fair?
That's not fair. In my second reading speech, I spoke to data from a study that was conducted, I can't remember the exact name of the study, a study conducted in Ontario that spoke to...
I think it may be
Transpulse study, sorry. So I provided
it's called Statistics from the Transpulse Project to Inform Human Rights
Well, that's
Policy.
wonderful. Now we have the chairman helping you out.
I'm sorry, Mr. Falk, but I actually did indicate that I spoke to a study in my second reading speech. I'm answering your question, and I would ask for the respect to hear a response from it and not, I don't understand where this acrimony is coming from. I was answering your question. I'm sorry that I didn't remember the name of the study off the top of my head.
Okay, I accept that. You indicated in your interview on Power and Politics that you really didn't think there would be a significant change. And I'm wondering if you're aware of any particular cases, if you can cite any, that were unable to be prosecuted because of our existing laws, that would have seen successful prosecution given had Bill C-16 been enacted.
Well, I think that one of the purposes of bringing this legislation forward is to show Canadians individuals among the trans population, that their rights are protected in law. And how many of those individuals feel that they do not have the ability, or there isn't a safe place to freely express themselves. We need to move beyond that. And I would, in terms of the significance of Bill C-16, and I certainly would point to the many individuals that I've met, including a very young lady by the name of Charlie that was present when we introduced this legislation. This, for her and my interaction with her, incredibly emotional, and she feels incredibly empowered that the Government of Canada has recognized that there is discrimination and that the government is seeking in Parliament, I hope, to do everything we can to eliminate that discrimination so she can be proud of who she is, that she can feel that her views and the way she feels about herself are welcomed, and that we can provide the space for her to be as successful as she wants to be. That is where the substantive nature of this piece of legislation is reflected in the eyes and the mouths of the individuals that are impacted.
My point is that I believe strongly that when we make decisions as government, it should be evidence and fact-based. And I see that missing here. And I think the legislation is addressing a gap that doesn't exist. I think our current description under both the Canadian Human Rights Act and the Criminal Code provides a broad enough description and adequate enough to prosecute all cases, including those where transgender people have felt discrimination. And I really don't think there's a need to be specific and explicit in legislation to address that concern. I think it's well addressed. Thank you, Mr. Chair.
Thank you, Mr. Falk. Mr. Garrison, the time is now yours.
Thanks very much, Mr. Chair. I want to start by thanking the Minister again. When this Parliament resumed, I reintroduced a private member's bill, and we had early discussions before this was introduced as a government bill, and I feel that the Minister has been very respectful of the work that came before her, and I thank all my colleagues for their kind words. But we're not here today because of my work. We're here today because trans Canadians stepped forward to demand the same rights, protections, and respect that all other Canadians have, and some very brave individuals came forward to tell their stories, both in previous hearings here in this House and in the Senate. And so it's that work and that courageous struggle that brings us to this place today. I don't want to do testifying. I want to ask the Minister some questions. But frankly, Mr. Falk's assertion that there's no gap and no evidence, I find offensive. It disrespects the work that's been done by all the trans activists. It disrespects the fact that Parliament has twice before passed this legislation. And the studies are quite clear. The TransPulse study from Ontario, which laid out the levels of discrimination and the levels of violence that people face, or even EGAL in Toronto, which did a study of safe schools, which was called Every School and Every Class. I also couldn't remember the title, which had transgender students testifying that every day half of them face harassment and more than a quarter of them face violence every day in the school setting. So the evidence is here that discrimination is very real and the need to act. And again, I thank the Minister for giving this priority. So my question is about timing again. My private member's bill, well, I guess maybe I should say one more thing. The reason expression was taken out of my private member's bill was negotiations with a group of members of the Conservative caucus, led by Shelley Glover, who had concerns that the public didn't understand and that the political repercussions of including gender expression would make it difficult. So in the negotiations over the bill in the last Parliament, I consulted with the trans community who reluctantly agreed that in order to get a bill through, because of the urgency, it was better to limit the bill somewhat than to have no bill at all. But it was a compromise essentially 4 years ago. I think the public has moved a long way since then in their understanding of these issues. So my bill passed in March of 2013, 2.5 years before the election, and it spent 2.5 years in the Senate. The Senate conducted hearings twice in 2 different committees and ping-ponged the bill around the Senate until it finally died. And so my question to the Minister is about the Senate and what her expectation is for the Senate in dealing with this bill. And in saying that, I acknowledge the new appointments today of some very prominent human rights activists among the 9 people named to the Senate. But I want to know if the minister's given some thought to, like all of us, how do government bills now work in this new Senate?
Well, I appreciate the question and certainly recognize the thoughtfulness of the questions that were asked around this table and the expression of support that was reflected in the House of Commons vote at second reading. And I hope that we move very quickly through the House of Commons into the Senate. I have confidence in the honourable senators to have, as they have on other pieces of legislation, dialogue and debate around Bill C-16. I do hope that there is a recognition of the need to have this legislation in place in terms of gender identity and gender expression. And as the Minister of Justice, I am very open, as I have been on previous pieces of legislation, to engage with at committee or individually with the honourable senators to answer any questions they may have and to provide any background evidence and studies that they would require in making their determination. But very much look forward to the swift passage of Bill C-16 into law.
Thank you very much, Minister. Thank you very much, Mr. Pentney, for your testimony here today. It is much appreciated. And colleagues, we're going to take a brief recess while we clear the room for our next in-camera session. Have a good day to the public.